Welcome everyone to our LinkedIn Live. I'm Tiffany Thompson, Director of Marketing and Communications. In this episode, we delve into the challenges facing litigators with artificial intelligence in copyright cases. Joining us today is Dr. Devon Madon, a pioneer in AI language model technology, and Elizabeth Babbitt, MA, a jury consultant with expertise in behavioral science and litigation strategy. They've just published an article titled Demystifying Generative AI for the Modern Juror, exploring the complexities of explaining AI to juries and judges. Leading our discussion is Adam Bloomberg, Senior Client Success Advisor. Good morning, Adam. Handing it over to you.
Thanks a lot, Tiffany. With all the buzz around AI and the legal challenges it's facing, it's important to get a clear picture of what's really happening. Dr. Madon, could you start by giving us an overview of really the current legal landscape involving AI in copyright cases?
Yeah, thank you so much, Adam. And please just call me Devon. So as Liz and I were really exploring, we're standing right at the brink of this new legal era. And the core of this current landscape that we're in right now, it's involving a multi-front legal challenge from content creators against the developers of generative AI. So essentially what's happening is that creators, so authors and photographers and people who've created all of this content are alleging that these large language model companies have used without their permission on this massive scales their work to train the large language models. So the cases we've been following really closely are the New York Times against OpenAI and Microsoft, and Getty Images against Stability AI. So these right now are still unresolved, and the big question that's coming up is about what constitutes fair use under copyright law. But what we're really focusing on right now is how important it is even just to explain the inner workings of training a large language model to a non-technical audience like judges and juries.
Liz, as the jury consultant in the room, why is it important for trial lawyers to begin to master these AI concepts now rather than waiting for more case law to develop?
Yeah, AI is moving really fast, and our law students coming out of law school are already using these tools. They're being taught classes on prompting and prompt analytics. It's really important that we, as the experts in the loop who've been working in the field for a long time, are already starting to get use in these tools and working in this space right now, staying AI agnostic, as we are still learning which tools will shape out and which tools will work best for us as we are making our way through this space. Today's cases are going to be shaping AI jurisprudence for decades, and walking into court, if we're unprepared for how these tools are being able to be used in the courtroom today, is just going to cause a lot of anxiety, and it's not going to make us look prepared for how we're going to be able to deal with tomorrow's technology today. So early mastery is going to enable us to shape history rather than just simply reacting to these emerging frameworks.
So Devon, it's been said that, to present to a jury with a wide array of educational backgrounds and life experiences that they bring to the courtroom, that you got to approach it like it's an 8th grade science class.
Yeah.
So as a testifying expert, how about a definition of large language models?
Absolutely. So a large language model is going to be an algorithm that predicts what language is going to come next. So the way that large language models work is that large language models are trained on enormous data sets, absolutely huge, that is going to be mostly coming from scraping the internet, as well as from open published book sources, and some of this material that is currently being debated in the courtroom, like the New York Times cases. But it's this enormous collection of just the written word, language. And then what a large language model does is that it's able to associate language with other language that it's most often found in patterns with. So it's a pattern recognition machine. So even though we talk about generative AI, it's not actually generating new material. It's taking calling from this wide, enormous, vast library of information and using that as predictive text to say what is most likely statistically to be the next, word that comes into this particular collection of language.
Now, that's a really good testifying expert example.
Thank you.
Liz, let's drill down even more. Let's make a simplified version of that for the jury. What would that look like?
So I would just say these are massive libraries that have learned how people speak. And rather than creating artificial intelligence that thinks for itself, we've really created systems that are just the next best word guessers. They're really good at their job, so good they work like magic. But once technology and AI technology, to Devon's point, has been around for long enough and it becomes a part of what we do every day, it tends to just be accepted as software.
Okay, so Devon, given the just rapid advancement of AI, particularly with these large language models like, what is it, Chat GPT 5 and Claude Opus 4.1, it seems like it's a moving target. It's going fast. So how can we ensure that juries fully comprehend all these complexities of these models in these copyright cases?
Oh, Adam, you're exactly right. It is a moving target. And so that's really the central problem that Liz and I are addressing. So first of all, you can't try to turn a juror into a computer scientist. It's just not going to work. And so that approach is inevitably going to backfire. And this is what experts like Liz get into, talking about cognitive overload.
All right, so Liz, back to you and your experience. What's the single biggest misconception jurors have when they hear just simply AI?
Yeah, I think the thing that's going to be the biggest misconception for jurors is that AI actually is intelligent and that it knows things. But the truth is that AI doesn't actually know anything. It has no feelings, it has no awareness, it has no truth, except for what's fed into those models, what we tell it when we're prompting it, and then what we're bringing away from it when we walk away with our responses beyond AI. So in copyright litigation, for example, when jurors are perceiving that AI has consciousness, they apply moral intuitions about machine behaviors rather than establish legal frameworks for evaluating fair use, substantial similarities, or commercial harm. And that's a real issue when we're faced with whether a machine actually has the ability to do these things. So messaging consistently throughout that it's operating only as a sophisticated pattern matching technology and not as a thinking intelligence on its own is going to be critical for ensuring that those messages are carried throughout your case as you move forward in your litigation.
All right, so you wrote in here, it's a little bit about comprehension. So staying with that, can you identify or explain split attention and cognitive overload? And I think you said that those were really impediments to that comprehension. Can you tell us a little more about that?
People are naturally lazy thinkers. Now, it's not to say that we're lazy thinkers, it's just to say that the world itself, in terms of stimulus, is overwhelming. Therefore, in order to simply make it through our day from the time we're awake in the morning until the time we go to bed, we must simplify everything into heuristics, right? Heuristic shortcuts, just so that we can make it through. A part of that thinking for jurors is to simplify information into stories that conform with our knowledge of the world, our experiences of the world. So much like what we're doing in this case, where we've taken a art student framework to explain to jurors the mechanics and workings of AI, we're trying to offer jurors something that melds with their own thought patterns and processes, something that they can relate to in their own lives, and then give them that experience to explain a more complex process so that they don't have to come up with something on their own in order to do the same thing.
The art student in the museum analogy from your article is such a powerful narrative tool. I love that. I'm actually going to I'm going to bring up a couple of those examples of your pictures. Okay, so how did you land on this metaphor, and what qualities make it, I don't know, is especially effective compared to maybe some other analogies that you've suggested to trial teams?
Yeah, so unlike a mechanical analogy that will distance jurors from the process, this art student analogy is going to leverage familiar human experiences while maintaining crucial distinctions. So here in this first frame, you were seeing the art student look at various images while just taking in how they're different without memorizing them. They're just learning principles, not specific works. In the next set of images right here, you're looking at how she's taking those different pictures and putting them into different groupings, different wings in the museum, for example, how they fit with various exhibits. And then in this third image or chunk, we're looking at how she's taking what she's learned outside the museum, and then while sitting next to a different student, is painting her own version of what she's seeing in front of her, and how those two things can look very different, even though they're looking at the same thing, because they're maybe described something different or they have a different slightly view of that same material. So the art student is working in that it's giving jurors the same framework while maintaining the distinction of what AI is doing with this same information in the same way. So in the article, we talk about how the human mind is the gestalt. It's understanding what a Van Gogh is. AI is perceiving the pieces that make up the gestalt, the way the color patterns and the textures of art are, to Devon's earlier point, pattern matched, and looking at that algorithm to predict what goes with what over the course of millions and millions of pattern matches to guess what someone is wanting over time. And that's how it's coming up with its images. So that's the difference between how AI is creating its thing versus the way people are imagining that same view at once.
Love that. Love that example. Devon, you get the last word. As generative AI continues to evolve rapidly, how do you envision the role of experts like yourself and trial teams and the folks that Liz works with changing over, I guess, the next 5 years, but maybe over the next 2 years when it comes to AI?
Oh, 5 years feels like a really long time in this world. But what I can tell you is that people like me who are in the world of large language model training, what we're seeing happening right now is that we're shifting from purely generative AI mode. So think of all the things that we've already talked about, ChatGPT and Claude and Gemini, right? They're generating. What it's going to be moving to, and this could happen in 5 years or it could happen way sooner, still to be determined. Some of this is already happening right as we speak, but it's going to be moving to an agent-focused AI, an agentic AI. So here's like the difference between them. A generative tool, you give it a prompt and it's going to generate a response, and it acts like a sophisticated partner in conversation. And that's what we currently have, right? So let's say I have a complex goal that it's like, okay, summarize all these new filings in this case, flag any scheduling conflicts. What it's going to be able to do is that the AI itself, the algorithm, will be able to access the data, analyze it, and then it can go right into my calendar without any further prompting. So when the agent starts acting on behalf of the user, it's going to feel like it's totally seamlessly multimodal, right? But what's actually happening is that it's going to create all of these complex challenges that are going beyond the current copyright disputes that we're thinking about right now. And this is going to bring up a whole slew of new legal questions. But at the very core, the stuff that people like me who are large language model trainers are currently worried about is going to continue to be a real priority. And that's going to be stuff like safety, right? Are we actually providing material that's safe and that doesn't cause any additional harm? What biases are we bringing in of our own to the way that we're training and using these models? As well as things like protected data of the users. How are we assuring that that protected data is going going to stay private and is only going to be used for the purposes that the user sets out. So all of these issues that are already in the big steaming pot of complexity are only going to become into sharper focus as we move from generative AI into agentic AI.
Thank you both for spending time with me today. I really look forward to speaking with you in the future after a few more cases and after some more research and another article or two. Thank you so much.
Great to spend time with you. Thank you, Adam.
Thank you to our guests for speaking with us today. To discover how the IMS team can help give your case an edge, check out imslegal.com or shoot us an email at contactus@imslegal.com. IMS has served trusted law firms and corporations worldwide for more than 30 years and over 65,000 cases. As a strategic partner for the full case lifecycle, our integrated teams provide specialized advisory support, expert witness services, litigation consulting, visual advocacy, and presentation technology to elevate strategies and protect hard-earned reputations. Learn more at imslegal.com.